Hi everyone, Mitch Jackson, Jackson & Wilson, www.jacksonwilson.com. When we are retained as counsel, we provide our clients with an instruction sheet, a sheet that contains do's and don'ts that if they follow will allow us to effectively represent their interests and do a great job for them. What I want to do on this video is quickly go through those 9 items with you. The first thing we ask the client to do is to always keep us updated with respect to their contact information, telephone number and address, whether or not they're going to be out of town on vacation. It's sometimes really important for us to be able to get a hold of a client, and as long as we've got your updated information, we'll always be able to do that. The second step is we always tell clients to refer to us, and what I mean by that is when they get an incoming phone call from a police officer, private investigator, insurance company representative, we ask the client to thank the person for calling, let them know that they should contact their attorney, Ms. Wilson, Mr. Jackson. Their number is, provide our number, and then get off the phone. Same thing applies to incoming correspondence. We ask them to forward any incoming letters, reports, questionnaires to our office for review. We ask the client not to sign anything until we tell them it's okay to do so. The third item on our to-do list is to preserve all evidence. Put together all photographs that you have concerning your case. Put together a list of all witnesses that are involved in the case. Put anything that might be relevant concerning your case into a folder so that we can look at it, evaluate it, and see whether or not it's something that we want to use when representing you in your case. The fourth item on our to-do list is we remind our clients to always be honest and forthright with us. If you're honest with us, we can do a good job for you. If you're upfront with us concerning any issues in your case, we'll be able to deal with those issues from a legal perspective and properly counsel you on what your options are. The next item on our list is we ask the client to always keep us updated. Keep us updated as to how you're feeling. How's your physical rehabilitation coming along? With respect to loss of earnings, out-of-pocket damages, we ask the client to always keep us up to date as to whether or not you're going back to work, whether or not income's coming in, whether or not bills have gotten so bad that you're having a difficult time paying them each month. Keep us updated on all of these items so that we can properly document the file and let opposing counsel know or the insurance company know that we're dealing with as to your current status. We also ask our clients not to discuss the facts of their case with anyone. This includes family members, this includes family, friends, neighbors. Don't discuss the facts of your case with anyone. Make sure all facts of your case are communicated through your lawyer. This allows us to manage the case, make sure that nothing is said or done that will compromise our ability on your behalf to do a really good job for you with respect to the settlement or trial of your case. The seventh item on our to-do list is we insist that our clients not provide any statements, whether they're oral or written, to anyone. Okay, rarely will we allow our client to give a statement. If it's ever approved, if it's ever done, it's going to happen in our office, it's going to be recorded, we're going to be in full control of the situation. But once again, no telephone statements, no written questionnaire statements, nothing gets said by the client, and everything needs to come through our office. The eighth item on our list is similar. Don't sign any documents, don't sign any questionnaires, don't sign any releases concerning your case. Make sure everything comes through our office. Let us evaluate the document before you even think about signing it. In many instances with respect to medical authorizations, what we'll do is we'll take the authorization that's sent to us from the other side, we'll narrow it down a little bit, and we'll give them access to medical records relating to the accident or relating to the injury. But by narrowing it down, what we're going to do is avoid them having access to all of your medical records from the date of birth 35 years ago up to the date of accident. It's not relevant and they're not entitled to it. The ninth item on our to-do list is we remind clients do not put together a daily diary. Do not write down items in a notebook. Do not record by video or audio your recollection, your memory of your injuries, your medical treatment, or what have you, without our participation. There's a certain way to document the history of your injury. the recovery process through physical therapy, through surgery. There's a right way and a wrong way to do it. We want to make sure we choreograph that with you. We want to make sure that it's accurately done. And the way we go about doing that, it's in a way so that we can present this evidence effectively at time of mediation, arbitration, or trial. So follow those 9 tips, and regardless of whether or not we're representing you or another law firm's representing you, it'll really help your lawyer do a good job in protecting your legal interests. If you have any questions, give us a call, 1-800-661-7044, or all of our other contact information can be found online at www.jacksonwilson.com.